This is William and Lonsdale, a podcast about the legal ecosystem in Victoria and the fascinating people and stories that make it tick. Today, your host Michael Green welcomes former Attorney-General of Victoria, Rob Hulls AM. Rob had an enormous impact on the Victorian justice system during his time in office, including introducing the Koori Court, Drug Court, Australia's first Neighbourhood Justice Centre, and the Victorian Charter for Human Rights. Pretty impressive for someone who didn't have the marks to get into law school. Before we begin, a warning that around the 8-minute mark of this episode, Rob's retelling of his arrival in Mount Isa and the racism he witnessed is confronting and sobering. It's also incredibly important to face these truths, but please skip between the 8 and 10-minute mark if this is not something you're up to hearing today.
Can you imagine, Michael, what it's like being at Government House, being sworn in as the Chief Law Officer of the state of Victoria? Like, it's a formal ceremony. It was an extraordinary day. All I was thinking of was, Mark's not good enough to get into law, and now I'm the Senior Law Officer of the state of Victoria. What an extraordinary turn of events. And as exciting as that day was, I knew I didn't have a second to waste. And, it was a privilege being Attorney-General.
Good morning, Rob Hulls.
Michael, great to be with you.
And it's great of you to come, Rob. Thank you very much. Let's go back to the start and set the scene. You're the second oldest of a large family, 6 or 7 children? Seven
kids.
Children. Your dad's a solicitor with his own firm, Frank C. Hulls & Co. What influence did growing up in that family have upon you and upon your journey through the law?
Big family. We used to have, at one stage, Mum had 6 kids all under the age of 8, so you can imagine we're all pretty close. We used to have almost every Sunday open house where people would come round. Dad would cook the barbecue. We'd have discussions about what was happening in the real world. Social justice issues were raised regularly. Dad volunteered at St Vinny's on a regular basis, helping homeless people with their legal issues and the like. So that sort of that social justice stuff gets instilled in you, and I guess that helped me form my views as to what I sort of wanted to do when I grew up, when I got a bit older. And whilst it wasn't necessarily the law, it was making sure you can do something that can help other people. That was formed as a result of the family background.
And your way into the law was not the traditional get high marks, go to Melbourne or Monash Law School and come out and do your articles at a big firm. You had a different path which seemed to suit your personality. Could you explain that path to us, please?
Yeah, well, you can't tell anyone this, and any listeners aren't allowed to tell anyone, but my marks were nowhere near good enough to get into law. Like, I was keen on doing law, obviously, because of the stuff I've told you about, and the old man was a lawyer. And I liked legal studies at school, but when I did what was then was it matric or VCE, whatever it was, marks nowhere near good enough to get into law. And a lot of doomsayers said, give up on that idea, there's no way you'll ever be a lawyer. I did get into arts at La Trobe University. I hated it, not because there's anything wrong with La Trobe or arts, but it wasn't law. But when I was at La Trobe, I found out about this law course, the Article Clerk course at RMIT, where you worked in a lawyer's office during the day, you went to lectures in the morning and at night, and I thought, that suits me. And so I wrote to RMIT whilst I was at La Trobe. I wrote to them on a regular basis. Some would say I stalked them. And I should know because I introduced stalking laws when I became Attorney-General. But I continued to harass them, and finally I got a letter back from them saying, stop writing to us. If you pass arts at La Trobe, there'll be a place for you in law at RMIT. I couldn't believe it, and I did pass arts and then finally I was doing law. So I always give young students a message: don't be put off by the doomsayers who tell you you're not good enough to achieve something. If you're passionate enough, there's always a way to achieve what you want to achieve.
I'd like you to tell us a bit more about the Article Clerk's course. When I was a young lawyer or came out of law school, I thought the Article Clerk's course was probably better than going to university in terms of preparation for working in the law, and yet it no longer exists.
It was a very practical course. It, as I said, lectures in the morning, tutes at night.
And can I just... lectures by leading practitioners, I seem to remember.
In many cases, leading practitioners, people who had real-world practice in the law, hence the practical nature of the course. I think I was in the second last year of the course. I was admitted on the 1st of March 1983, so I would have graduated from that course probably in 82, and I think that was the second last year of the course. I think one of the reasons they got rid of it was, the usual thing, churning out too many lawyers, too many law courses around the place. We don't need that course. But basically, it was a fabulous course, very practical, produced some fabulous graduates. I wasn't a fabulous graduate, but, judges. I think John Coldry did the course. John Smallwood, who I know you've interviewed, did the course. At RMIT now, there are 2 law courses. There's the postgraduate law course, which has been going for over 10 years. So it's a JD program, a bit like other mainstream universities. But they've just reintroduced this year an undergraduate law course at RMIT. So you can go straight from school to law at RMIT. So there's obviously a big demand for it.
Yeah, it's interesting. Also interesting is you finish your law course, you're admitted, and you've in those 5 years of doing the course, you've had 5 years of practice working for your dad. But soon thereafter, you wind up in Mount Isa. Now, you're a boy from Melbourne, went to private schools down here with a checkered history, and you finish up in outback Queensland. How'd that come about?
I'd actually planned to come to the bar and use the privilege of being a lawyer to try and assist disadvantaged members of our community. I worked for Legal Aid for a little while, and then I saw a job advertised working with an Aboriginal legal service in Mount Isa in North Queensland. And at that stage, my parents were living on the Mornington Peninsula. I'd never been to Mount Isa, never met an Aboriginal person, and I thought, this is taking myself outside my comfort zone. I think I'd like to do it. It might be a bit frightening, but I'd like to do it. And I remember going to the old man and said, look, I've applied for a job in Mount Isa. And I remember him saying, what the bloody hell do you want to work in Mount Isa for? And I said, no, not Mount Isa, it's Mount Isa. So we had to dig out a map and show him where it was. But can I say, Michael, yes, it was scary going up there. I didn't know a soul. I was the fella doing the Aboriginal legal aid work. And, I was demeaned by many in the profession up there as a result. It was the most extraordinary experience of my life. It changed my life, and it set a roadmap for everything I did when I got into politics and everything I've done since. It was quite extraordinary.
And you have said that you quickly realised that the justice system, at least up there and maybe everywhere, is racist. What led you to that conclusion?
It took me about 2 minutes after I arrived. I was taken off to a welcoming barbecue, and at that barbecue, a police officer came up to me and said, you're the new bloke here to do Aboriginal legal aid work? And I said, yeah. He said, what sort of work are you expecting to do? And I said, I had all the lines right. I'm expecting to represent the most disadvantaged members of our community. I'm here to make a difference. He said, yeah, good on you, mate. He said, say if I was to tell you that last night in the Mount Isa jail, in the watch house, an old Aboriginal bloke was arrested just for being drunk. And I said, yeah, well, he'll be one of my clients. I'll do the best I can. But he said, no, you're not listening. Say if I was to tell you that while he was asleep on the watch house floor, the officer in charge of the watch house went over to him and started force-feeding cockroaches down his throat as a bit of a game. And I was a bit like your face, Michael. I was aghast in dismay. And he said, see, the attitude you've just shown, one of disbelief, is the same attitude the magistrate will show when the accusation is made in court. The Aboriginal bloke won't be believed, but it happened. This type of thing happens all the time, mate. You need to realise the sort of justice system you're coming into. And by the way, good luck, I'm leaving town.
So was that policeman, he was also dismayed by that justice system in Mount Isa, but he was saying, I'm the only policeman who really cares and I'm leaving.
He seemed to be saying that. He seemed to be saying, this is the sort of stuff that happens up here, and in effect, I've had enough, I'm leaving. I didn't know if he was saying that sort of stuff to frighten me or, to put the heebie-jeebies up me, but the reality became pretty clear to me very quickly. That was just the tip of the iceberg, just the tip of the iceberg. Some of the stuff I saw up there, Michael, you wouldn't believe and your listeners wouldn't believe, but it was quite extraordinary the way Aboriginal people were treated by a totally unjust justice system.
William and Lonsdale is brought to you by Greenslist, one of the leading multidisciplinary barristers lists in Australia. Greenslist believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community. In
Mount Isa, your political career starts. What was the starting point for it? What created it? Why did politics suddenly come on the radar and you say, yes, I'll become a politician?
After doing the Aboriginal legal aid work I'd only planned to go up there for 1 year to get some experience and come back to the bar, or come to the bar in Melbourne, lined up someone to read with. But it was so compelling, the work up there, that I did the Aboriginal legal aid work for 5 years. And acting for people on a case-by-case basis was important, taking the fight up to the police, trying to receive some sort of justice for Aboriginal people was really important. But I realised if the laws were racist, if the system was a racist system, was not culturally sensitive, how do you actually change the system? Yeah, you can act for people on a case-by-case basis, but to bring about systemic change, you've got to change the laws. Best way to do that, run for Parliament. So I actually ran as a 32, 33-year-old kid after doing 5 years of Aboriginal legal aid work, ran for federal Parliament up in North Queensland, the seat of Kennedy. And lo and behold, Michael, I got elected. Boy from Melbourne, marks not good enough to get into law, Aboriginal legal aid lawyer. All of a sudden, I'm in the federal Parliament. Had never been to Parliament House before, the new Parliament House, and I'm a federal member of Parliament when you've got people like, Bob Hawke as the Prime Minister, Paul Keating as the Treasurer, John Kerrin as, the Minister for Regional Victoria and the like. It was an extraordinary experience. You can imagine being a young kid from Melbourne, then being elected to federal Parliament in an outback rural electorate, which was traditionally a National Party seat. But as happens with most politicians, Michael, comes the next election, I got beaten. And again, your listeners can't tell anyone this, but I got beaten by that Rhodes Scholar, Bob Catter. And so I'm really
who is still a member.
I'm the one to blame for Bob Catter being in federal Parliament. So I apologise to everyone for that.
You've said that you realise you can actually do something in politics, that you could bring about change. I mean, a lot of us as consumers of politics and spectators of politics and occasional participants when we vote, sometimes wonder, can you bring about change? Do we see change? Why did you think you could? Was it because of those times with the Hawke government? Or in general, do you think our system, in fact, is more open to change than maybe we might think?
To be frank, I think most people who do go into public life, including politics, do so originally for the right reasons, and then some get captured by the system and they forget the reason they're there. I knew that in federal Parliament I was only going to be there for a short period of time because of the demographics of the seat. I knew it was traditionally National Party. The former member was Bob Catter Senior. He'd passed away, and so I knew I didn't have a minute to waste, and I worked as hard as I could to improve, in particular, the lot of Indigenous people in my electorate. And that's because of the background I had in legal aid work, Aboriginal legal aid work. But I knew it was going to be short-lived, and I wasn't going to play any factional games. I wasn't interested in any of that sort of stuff. I was just interested in improving the lot of my constituents in North Queensland. Can you bring about change? Yeah, you can. You can. If you can win the trust of the people that put you there, that gives you a huge imprimatur within the system. I was just a small cog in a very, substantial government. I was a first-time backbencher, but because people knew that my background was a bit different, I was almost the accidental member for Kennedy, I got a lot of ministers to listen to me and come to my electorate and realised I wanted to make a difference, and they helped me do that.
That's encouraging for all of us. You come back from Mount Isa and from Canberra as the member for the seat of Kennedy, and politics is in your blood. You become Chief of Staff to the Victorian Opposition Leader, Jim Kennan, and from there you ultimately become the state member for Niddrie. How did that work? Were you a member? Did you need to be a member of a faction to get pre-selection?
So I came back as the defeated member for Kennedy, and I needed a job. Wasn't going to stay up in North Queensland. I wanted to come back to Melbourne. I saw a job advertised working as Chief of Staff to the Leader of the Opposition, and I'd been out of the state for a while. I didn't know who the Leader of the Opposition was in Victoria at the time. Found out it was Jim Kennan, did a bit of research on him, wrote a letter, sent my CV, and I remember at the end of the letter I said, P.S. I'm a Mad Geelong supporter, because I knew he was. And I got an interview and I got the job. I wasn't in the job for very long when the late, great Jim decided he'd have enough of politics and he resigned. And I thought, God, there goes my job. Then the caucus voted for a new Leader of the Opposition, happened to be John Brumby. I wasn't sure if Brumby was going to keep me on. I vaguely knew him through the party, but not very well. But he decided to keep me on as Chief of Staff. we formed a very close relationship. We became very close mates. And then when the seat of Niddrie became vacant in a by-election because the then member went to federal parliament, and so there was a vacancy there, Kennett was about to call a state election, but the by-election had to be held before the general state election, so the Liberals didn't even run a candidate in the by-election in Kennedy. I got pre-selection and I was elected unopposed, Michael, unopposed as the member for Niddrie. And I knew after being elected with what I called 100% of the vote, it was all going to be downhill from then on. You couldn't get that many votes again.
You didn't need then factional support throughout your career as a politician. I mean, it seems to me very hard, whatever side of politics you're on, it seems to be difficult not to be a part of a faction, to have the support to get pre-selection, to get things done. Were you a part of a faction?
Not when I was a federal member. I wasn't even sure what factions were, but when I came down to Victoria, the seat of Niddrie, when it became vacant, was known as a right seat, a seat allocated to the right, and so I formally joined the right. But let me tell you that factions aren't necessarily based on philosophy. It just so happens to be a power-sharing arrangement. All parties have factions of one sort or another, so I was nominally a member of the right faction, which enabled me to get pre-selection for Niddrie, and my career went from there. I was the member for Niddrie in my entire time in state parliament.
So how long after you became member for Niddrie did the ALP under John Brumby win power? So
Brumby was leader for a number of years. I was sort of the scrutiny of government person within the opposition, so I was, had to take up some of the ugly fights to Kennett. But then Labor changed its leader. It was a smooth change. Steve Bracks took over from John Brumby, and of course Steve Bracks won the 1999 election. I had been Shadow Attorney General and I became Attorney General. And can you imagine, Michael, what it's like being at Government House, being sworn in as the Chief Law Officer of the state of Victoria? Like, it's a formal ceremony. It was an extraordinary day. All I was thinking of was, Mark's not good enough to get into law, and now I'm the Senior Law Officer of the state of Victoria. What an extraordinary turn of events. And as exciting as that day was, I knew I didn't have a second to waste. And, it was a privilege being Attorney General.
Were your mum and dad still alive at the time?
Yes, absolutely.
Oh, that's
absolutely.
Wonderful.
And very proud. In fact, Dad had retired from Frank C. Hulsen Co, but he was volunteering. He volunteered for 8 years at the Flemington Kensington Community Legal Centre. And I often would get a phone call from the old man. And, of course, my PA had put it through because it was Dad. Yeah, Dad, what's up? Oh, g'day. How are you, Rob? Yeah, good, Dad. I'm pretty busy. Yeah, I'm busy too. I just need some legal... Dad, I can't give legal advice. He said, no, I've got this client in the Housing Commission flat. Oh, Dad, I'm just not allowed to give legal advice. And so, I'll bugger you. And he had those conversations almost on a weekly basis.
Sounds like a pretty good dad to me. In your time as Attorney General, you introduced and established an impressive list of firsts for the state of Victoria, and I think quite a few of them then influenced other jurisdictions. Things such as abolishing laws which discriminated against people in same-sex relationships. The Victorian Charter of Human Rights, I think, was something your child. You set up quite a few special courts, the Koori Court for Indigenous people, special court for people with mental health issues, people with drug addiction, victims of family violence. Why did you think there was a need for special courts? Why wasn't the existing court system adequate for our needs? What was your driving force behind that?
I had a pretty simple philosophy, Michael, and that is that people's lives go along a certain track, and some stage they might have ups in their lives, they might get married, get their first house, get their first job, and then there could be down times in their life where there could be a death in the family that might lead to drug and alcohol issues, mental health issues, homelessness issues, long-term unemployment issues. And at that horrible stage in their life, for some reason, they might come into contact with the justice system. It could either be as a perpetrator or as a victim. The view I took was the justice system, as it currently existed, often pushed them further into the mire and further ruined their lives. The view I took was a justice system should be able to act as a bit of a trampoline and bounce their lives back on track. So how to create that positive intervention in people's lives with the justice system. And that's why I created a lot of those specialist courts. It was after substantial consultation. The Koori Court, for instance, was part of the Aboriginal Justice Agreement, but it was after consultation with the Koori community, but also based on my lived experience in Mount Isa, seeing how bad the justice system could be without some sort of cultural sensitivity, without some sort of real involvement from the Aboriginal community. The family violence courts, for instance. I knew family violence was a huge issue, but the police at that stage were just treating family violence matters as domestic, And I wanted to have...
can I just break in there, Rob, for people of a different generation than you and I, a domestic meant the police had nothing, they just hands off.
Yeah.
It's a domestic, we won't get involved.
A domestic dispute. But I wanted to encourage women to come forward and report family violence, and I wanted to have the police retrained in relation to family violence matters. I wanted to have specially trained magistrates, specially trained court staff who could put wraparound services around people who are reporting family violence, hence the family violence courts. I had a brother who had mental health issues, and time again he'd come into contact with the justice system, he'd have to repeat his story, bipolar, and it was just a horrible experience for him that compounded his issues. So I wanted to have mental health courts that actually put holistic support around people who were coming into contact with the justice system because of their mental health issues. So these courts have all been independently assessed and they work, and I'm pleased to say that hopefully they're now a permanent part of the DNA of the legal landscape here in Victoria.
What about the Charter of Human Rights? Why do you think it was necessary, or what? And can you maybe give us a bit of an explanation for what it is and how it fits into our legal system? And going forward, what is it doing? How is it protecting my rights and protecting the rights of all of the citizens of our state?
Sure. So the Charter was introduced. The Act was known as the Charter of Human Rights and Responsibilities Act, and we set up a group to have consultation right around the state with Victorians in barnyard sheds, in town halls. It went on for quite some time to see whether or not Victorians were of the view that the rights that they had were adequately protected by the law. And their view was that in particular their civil and political rights were not adequately protected. And as a result of that consultation, I decided to introduce a Charter of Human Rights and Responsibilities to better protect people's human rights, civil and political rights. And as a result, that charter is, again, a permanent part of the legal landscape here in Victoria, and it puts a brake on government excesses. It's, I guess, a ground rule for government to follow, a roadmap for governments to ensure that any piece of legislation that governments introduce in this state that affect Victorian citizens have to have an eye to the human rights of those citizens. And no right is absolute, but if the government wants to infringe upon the civil or political rights of any Victorian, they have to explain to the Parliament why they're doing it. They have to give reason, and there can be debate within the community about whether or not that is a good thing. So I think the Human Rights Charter is a good thing. I find it astounding that we're the last nation in the Western world that doesn't have a federal human rights instrument. I think that we should. It's all well and good for politicians to be traversing the world complaining about human rights records of other countries when we in Australia actually don't have a federal human rights instrument. I think it's inevitable, and I think that the Victorian example should set a precedent for what can happen federally.
Bringing that forward to today, when we have a COVID pandemic and we have mandatory vaccinations and we have people. So let's say I'm a protester and I believe that mandatory vaccinations infringe upon or impinge my civil liberties. What about this Charter of Human Rights? Why are my human rights being infringed when I don't want to be vaccinated?
The Charter makes it pretty clear that no right is absolute, and that's why it's called the Charter of Human Rights and Responsibilities. And in the second reading speech, I made it quite clear that with rights come responsibilities, and everyone in the community has a responsibility to respect the human rights of others, and using human rights can't be used as a pretext to violate the rights of others. So everyone has a right to live in a society where, they have a right to appropriate health. For instance, if people don't want to get vaccinated, that might be their right, but they also have to ensure they don't infringe upon the rights of others to health. And that's why governments can make these regulations that on one view might infringe upon one person's right, but no right is absolute. So the greater good, if you like, is taken into account. That's a lay person's way of explaining what the Human Rights Charter is all about.
Rob, sometimes when we view politics, it seems to be a reactive sort of an occupation where it's the latest issue of the day that gets the attention of the politicians. You wanted to have a clear vision for the justice system and not react in a piecemeal fashion to the politics of the day or whatever's going on in the press. So you put together a 10-year strategy. How did you do it and what came out of it?
Well, yeah, I did want to have a long-term vision for the justice system. I put together a justice statement, and that was after consultation with all stakeholders throughout the justice system. I really asked them, what do you want the justice system to look like in 10 years' time? Should it continue to be adversarial in nature? Should we still have the current court structure that we do? Do we need to build new facilities, or why can't courts operate out of town halls? No question was off limits. And as a result of that, a whole range of things grew, including the specialist courts, including the Human Rights Charter. They all came out of that 10-year vision for justice. And I was pretty pleased to say that we had to have Justice Statement Mark II after about 5 years, because I think we achieved most of the things we set out in the initial 10-year vision within 5 years. And we were able to do that because we got buy-in. We got buy-in from all parts of the system. And I think people liked having some sort of long-term vision for the justice system. That doesn't mean that you're not dealing with the day-to-day stuff. Like as Attorney General, I was dealing with stuff on a day-to-day basis. It was one of those early morning portfolios where, there might be a court decision handed down overnight and people were annoyed about a particular sentence that was handed down. It was on the front page of the Herald Sun, so they dragged the Attorney General out to comment on the particular matter. And I knew that was going to take up a lot of my time. That's why I wanted to have this long-term vision as well, because it sends a message, apart from anything else, to the public service, to the departments, that, yeah, he might be dealing with some of the day-to-day stuff, but we should be working on this long-term vision with him.
We have an overall plan.
Yeah.
One of the other things that you changed, and I'm not sure this change has stayed to this day, was the appointment of judges. Traditionally, the Attorney General, I think, took advice from senior members of the profession and then spoke to a chosen person, who was typically a man, and offered that person the job on the court, whatever court it might be. You introduced an open tender process for people to apply for positions as judges. Why did you do it? Why did you think it was necessary? And was it a success?
Was it a success? It depends which side of the fence you're on. So, yeah, when I became Attorney General, as you would know, Michael, you've been in the game for a long time, the legal profession is pretty conservative. And when you were, much younger, and when I was much younger, and I must remind your listeners that Michael is older than me, most of the profession was made up of male, pale and stale people, or the bench was. And the procedure was, there'd be a certain little cohort that would make a recommendation to the attorney, and you're right, usually always blokes, and the attorney would then appoint that person. I wanted to broaden the pool from which I could make those decisions. I consulted very widely with every appointment. It was one of the most difficult parts of my job. I agonised over judicial appointments because I knew that they were going to be there for a long time, and it was really important to try and get it right. But I decided to put ads in the local news, Herald Sun and The Age, seeking expressions of interest for people who wanted to apply, rather than just go through the same old processes and speak to the same people. I did speak to them, but I wanted to broaden the pool from which I could choose. And we received some extraordinary applications through that process. I was absolutely vilified by many conservative male, pale and stale members of the profession, the bar. How dare you advertise these positions? It's never happened before, attorney. This is a disgrace. You're putting us in the same category as butchers and bakers and candlestick makers, and absolutely outrageous. I remember getting a call, I don't know how it came through my office, from one particular senior member of the bar. Again, telling me how outrageous it was. Attorney, it's absolutely outrageous that you would put these ads in local newspapers. It's never happened before. The bar absolutely objects, attorney. And for your information, I personally would not be applying for a position based on an ad in a newspaper. I said, right. He said, but attorney, nonetheless, if you felt it appropriate to appoint me to the bench, I would be happy to accept. I kid you not. Needless to say, I didn't appoint that person. But look, I just wanted a broader pool for people from which to make these very important decisions.
But it's not applying now. It's not being used now?
Oh, certainly. I saw an ad not terribly long ago seeking expressions of interest for people who want to be magistrates. So I think in certain courts it certainly still applies.
In the same vein, you tried to get off the ground part-time judges, and that one didn't get off the ground.
There has always been a system of reserve judges where judges who are retiring can come back on the bench for a period of time. Usually they're in their 70s and they come back on the bench, they're reserve judges. And I thought, well, because of, the way the system had worked for a long period of time, there was never going to be, for a long period of time, women reserve judges because women hadn't been appointed to the bench in great numbers and so they weren't retiring and therefore they couldn't become reserve judges. And I want to introduce a system where, a bit like the recorder system in the UK, where people can be senior members of the bar, for instance, or senior members of the profession, but can go on the bench for a couple of years. I did introduce what was known as part-time judges, but they're actually people who are very senior in the profession who could come onto the bench for a period of time. And it might suit their work-life balance. Appointed a number, again, as you'd expect, the usual suspects vehemently opposed that. And I don't think that happens. I think the only people who are sort of part-time now are reserve judges. Having said that, there are far more women who are now coming to retirement age and we'll have far more women as reserve judges. The real question is, do we need reserve judges? Should we go back to a situation where you can have people who are at other stages of their career that come on the bench for a few years? It certainly happens in other jurisdictions.
And last and not least, the complete shock and horror. You tried to do away with wigs.
Yeah, I was all part of the trying to modernise the profession, and that was one thing I knew would irk barristers, but I made it quite clear that if they wanted to wear wigs in the privacy of their own homes, that was fine, but wearing silly old smelly horsehair in a court was not a modern system. I'm pleased to say that many heads of jurisdiction now make it quite clear that barristers don't have to wear wigs in their courts. Look, I just think from a user experience, courts should try and be a healing place, not a frightening place. And I know barristers, it's part of their job. They appear in court on a daily basis. That's their regular job. But really good barristers understand that for people who are disputants in a court, defendants, bringing a civil action, that's the biggest day of their life. Someone who's appearing in the magistrate's court for the first time will have sleepless nights leading up to, what some barristers might think is a simple crash and bash matter. But it's the biggest thing in the person's life at that stage. And you just got to make sure that you can make it as comforting as possible. And that's why I tried to modernise our justice system to make it that far more soothing experience for people.
And very worthwhile too. One of the ones which interested me in the research that was done for today was you gave a posthumous pardon to a man called Colin Campbell Ross, who was executed for murder in 1922, so 100 years ago this year. Why did you think it was necessary to do that?
It was an extraordinary case, and just to show how swiftly justice moved in those days, from the time he was arrested, this Colin Campbell Ross, to the time he was executed, and this took into account all his appeals, took 115 days. So from the time of arrest to a time of execution was 115 days.
Which is about 4 months.
Yeah, just extraordinary. But evidence came to light in a book that was brought to my attention by a researcher that in those days DNA didn't exist. But there was evidence on his file that still did exist. And the main thing that convicted him was hair. And it was alleged that he abducted a young girl who was 12, sexually assaulted her and murdered her. He maintained his innocence right to the time he went to the gallows. This person was able to get access to the file and with modern technology was able to use DNA in relation to that hair, which was alleged to have come from Colin Campbell Ross's head. It was shown through DNA evidence that that hair did not belong to Colin Ross. From memory, I think it might have even been a dog's hair. And that was really the only evidence they had in relation to Colin Campbell Ross. I referred it to the Chief Justice to get an opinion. She referred it to three judges of the Supreme Court. Justices Teague, Cummins and Coldry, I think, and they came back and found that Ross was certainly a victim of a miscarriage of justice. As a result, I then supported a petition to go to the Governor to pardon Colin Campbell Ross. I've got to say that petition was supported by not just Ross's family, but also by the family of the young victim. And
so there were members of his family, Colin Campbell Ross, who grandchildren, great-grandchildren, whatever, who were still alive and could still participate, so to speak, in this piece of justice being done.
Absolutely. I say, very interestingly, the victim's family also supported the petition because they also realised when this new evidence came to light that there was a horrible miscarriage of justice.
Makes us wonder, of course, how many other such cases are there. We hope very few, but no doubt there would be some.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting. More information can be found on their website, themelbournemap.com.au.
Rob, 10 or 11 years you were Attorney-General of the State of Victoria, which is a long time in one job in politics. You brought in many reforms across a whole range of areas and had a real impact upon our state, and I suspect across the whole of Australia where other states took up some of your reforms. Are there any of them which you are particularly proud of or particularly grateful you had the opportunity to implement?
Yeah, it's a question I'm asked a bit, Michael. I don't sort of look back and think, oh, that was my greatest reform or that was. It was just having a pretty simple philosophy. Like I don't like to complicate things too much, and the simple philosophy was just introduce change to ensure that the justice system, where it can be a positive influence in people's lives. And that's why all those specialist courts were set up. I'm proud of them because they are now permanently part of the fixture here in Victoria. We've had different coloured governments come and go, but they've kept a lot of those reforms. The Human Rights Charter, that's here to stay. Like that won't go. And that, again, is a roadmap for governments of the future, of any political persuasion. Changing the face, if you like, of the bench by appointing women and people from non-English speaking backgrounds, that's here to stay. We now have a much broader pool from which to choose. So it was an exciting time. There's not one particular reform that I'm most proud of. I'm just pleased that many of the reforms continue to exist today, but if you stand still in the law, you go backwards. So it's important that all aspects of the law be looked at on a regular basis to see how we can improve it. Just because you introduce a reform doesn't mean it should just sit there in concrete. Why aren't specialist courts in all courts right around the state, for instance? We have a Neighbourhood Justice Centre here in Collingwood, which is a one-stop justice shop. Fabulous. But why just Collingwood? It's important that we continue to look at reforming the justice system because it is such an integral part of our democracy. And if we don't keep reforming, it goes backwards.
So, Rob, after 14 years in state politics, at a relatively young age, and still with plenty of energy and enthusiasm to do the job, you retire. Why did you retire?
A couple of reasons. I got a thing called epiglottitis, which was most unusual, and I was in an induced coma for 7 days, and that sort of made me realise that, life can be pretty short. But I had never planned that politics was going to be my last job. I wanted to get in, make a difference, and then get out and let younger people come in and take over, because reform is not just legal reform, but you also got to reform politics and renew seats and the like. So I was never going to be there for forever. The epiglottitis probably spurred me on to getting out when I did, and so I decided to get out. Despite what you might hear, Michael, about retired politicians, you don't all of a sudden get inundated with a whole range of, high-profile job offers. I think I got one phone call, and it was from RMIT and my old alma mater. And the then Vice-Chancellor of RMIT said, Rob, you've retired from politics for services to the community. We'd like you to come back to RMIT, and we'd like to make you an adjunct professor at RMIT. And I said, what the bloody hell's that? I didn't know what it meant. I said, look, I'm not interested in any particular title.
That's all right, Rob. We don't know what it means either. So you better explain what an adjunct professor is.
I think it's a Clayton's professor. I said, look, I'm not interested in any title, but if you're fair income, I wouldn't mind trying to open up a smart justice centre, a centre of excellence for learning, teaching and research in relation to smarter ways of doing justice. I sort of had the vague concept in my head. I wanted to try and continue some of the work I did as Attorney General, trying to make the justice system that positive intervention in people's lives. And the Centre for Innovative Justice was born, and we've been going now for 10 years.
Well, tell us a bit more about it. I mean, what is the centre? I mean, who staffs it, and what are the outcomes of what it does?
It's a great place. I would say that, wouldn't I, because I'm the director. But its aims are, as I said, to be a centre of excellence for learning, teaching and research in relation to smarter ways of doing justice. How can you introduce reforms, do the research, look at best practice around the world, but then advocate for those reforms at the highest level to get changes to the justice system that can better meet the needs of victims, better meet the needs of people with disabilities, better meet the needs of people who have mental health issues, better meet the needs of Aboriginal women who have been incarcerated at extraordinary rates. We've also co-located with 2 community legal centres, so Youth Law and the Law and Advocacy Centre for Women. They've become multidisciplinary practices, so we now have law students and social work students working with lawyers and social workers from these community legal centres, putting wraparound services around the most disadvantaged members of our community. So it's a great research place, advocacy place, but also a great place for students to get a life-changing experience.
Rob, there are a lot of think tanks throughout the country doing their thinking and making recommendations and creating reports, etc. And you're one of them, it would seem to me. You're not dissimilar anyway. How do you translate it into practical outcomes?
Yeah, good question. We're not interested in publishing or producing stuff that goes into a journal that sits on a shelf for 10 years. We're actually interested in having an impact, and that's our vision at the centre. Do stuff that actually has an impact and get into the hearts and minds of policymakers to change the way the system operates. And so let me give you an example. One project that we worked on was a spent conviction scheme where we worked with an Aboriginal organisation and we spoke to Indigenous people whose lives had been impacted by a very old conviction they got, wait for it, when they were stolen from their family. Young kids who were stolen from their families actually got in many cases, a conviction recorded for being a neglected child. That was on their record forever. So we worked with this Indigenous group, did the research, looked at what was happening around Australia and around the world, and then made recommendations to government in relation to a spent conviction scheme. That legislation has now gone through the Parliament. That is a huge burden taken away from these people. So we're interested in having a real impact. We're working in the area of restorative justice, for instance, where often the adversarial system of justice lets victims down. It doesn't give them the outcomes they want. Restorative justice, where in a controlled environment you bring victim and offender together, often gives victims a much better outcome than the adversarial process. Not only have we done the research in that area, but we're doing the conferencing. We're actually doing the restorative justice engagement processes. So we are making a difference. And I repeat, Michael, the law has to reform, look at itself on a regular basis to see how it can do things better, and we're part of that process.
And you have the ear of the Department of Justice now so that they are aware of what you're doing, or you can make submissions to them, and then things like the Restorative Justice Initiative, you've got the imprimatur, or you've been given the authority from the Department of Justice to do these things.
Well, in relation to restorative justice, for instance, we made a submission to a Law Reform Commission inquiry in relation to sexual victims of sexual assault, and we made a recommendation to the Law Reform Commission that restorative justice should be embedded in the system. The Law Reform Commission, which is now reported to government, has taken up our recommendation. And so when you say imprimatur, we make recommendations to royal commissions, to reviews, to governments, and then we follow it through by doing the actual work. So it's a pretty exciting place. It's the way of the future. I mean, I used to say that if a person came down from Mars 100 years ago and looked at our justice system, and then came down from Mars, today and looked at our justice system, they'd say that not much has changed. We have to change because our legal system is such crucial part of our democracy. It has to continue to evolve with the community.
I like one of the things you've said, which is that listening to the lived experience of those who have faced the justice system is the real key. A body like the Centre for Innovative Justice, I understand, would listen to the people who have had experience in the system. But as a community, are we interested enough to hear the experience of people who have been in the justice system? Or are we more interested in our own day-to-day lives and really don't take much notice of those who get chewed up and spat out by the system?
Sure. I think for too long our justice system has been designed by lawyers and judges for lawyers and judges without any eye to the users of the system. I've often said that if there was a trip advisor for the justice system, it would get no stars. What other organisation do you go to where you make an appointment? If you made an appointment with your local GP at 10 o'clock in the morning and you sat around in your GP's waiting room until 4, and that's when the GP saw you, get rid of your GP. That happens on a daily basis in our court system. Even at McDonald's you can get a buzzer that'll tell you when your meal's ready, but we still, demand that people roll up at court at 10 o'clock, despite the fact that, in all likelihood their matter's not going to get on till 3. We don't take into account the fact that they may have family responsibilities. They might have to pick up a kid from sport or childcare. There might be mental health issues, anxiety issues. We don't enough take into account the user experience, and we should. And at our centre, we are always looking at reforms that take into account the users of the system. We actually have a person on our staff who has an acquired brain injury, who's been in jail, who is an advocate and advisor in relation to improving the system for people with acquired brain injury. So it is absolutely crucial that we take into account the lived experience of people who come into contact with the justice system if we're fair dinkum about reforming it to improve their lives.
So, Rob, your experience in the law probably starts with your dad, I guess, in a small practice, then your own experience of in Mount Isa working with the Aboriginal Legal Service, then as the Chief Law Officer of the State of Victoria, and now at the Centre for Innovative Justice. With all of that experience, what are you saying to a young person who might be listening to this podcast who wants to have a career in the law, is inspired by the law? In a whole lot of ways. It might be inspired to be a commercial lawyer in a large firm. It might be inspired to be a legal aid lawyer. But what do you say to those people?
I'd probably say 3 things. First of all, be true to your values. Hold fast to your values. But in practical terms, don't be put off by those doomsayers in your life who tell you that you're not good enough. You'll never be a commercial lawyer. You'll never be a criminal lawyer. You're not smart enough to do law. If you have the passion and the vision, you can achieve anything you like. So don't be put off by those doomsayers because, being in the law is pretty competitive. You know what it's like at the bar, a very competitive place. There'll be people who'll try to put you down. Just don't be put off by them. And the other thing, really practical advice, is just from time to time, take yourself outside your comfort zone. Just do something that might scare you a little bit, that's outside the safety of your own little environment, outside the safety of your family, for instance, outside your current world of living. It changed my life. Like going to Mount Isa, way outside my comfort zone, was only going to do it to get a little bit of criminal law experience before I was going to go to the bar. Totally changed my life and set a roadmap for everything I've done since. So doomsayers, tell them to nick off and take yourself outside your comfort zone from time to time. You never know where it might lead you.
Rob, thanks for a most interesting and informative life in the law and for the contribution you've made to our legal community and obviously our general community, and that you continue to make. Great to have you here this morning.
Great to be here, Michael. Thank you.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue the discussion here today.